And then she said, Ms. Hill said, everything the defendant has said has been lies, and you should forget about the guns. They will never be seen again.
What?
Are those fleeting comments, or are those egregious?
What? Today we're going back into appellate court land with Mr. Alex Murdaugh, who wants a new trial. The allegations from Team Murdaugh are that the elected clerk of court, who has now since been convicted because she pled guilty of the multiple felonies with breaches of her ethical duty and obstruction of justice. She's a convicted lying liar that lies. She stepped down as clerk of court. She is now in retirement. It's so embarrassing for her. She's in retirement and on probation. And part of what's being alleged is that the clerk of court interceding and talking to the jury, it does not need to be shown. This is what Murdaugh's team are arguing. They don't need to show that Murdaugh was actually prejudiced, that the jurors are like, yeah, I dead ass changed my mind because she said he was guilty. But the fact that she was talking to them about the case is enough. They are trying to shift that standard so that the defendant doesn't have to prove that they were harmed by it or prejudiced by it, which is more akin to the federal standard from the US Supreme Court, different standard at the South Carolina Supreme Court. But they are also appealing on numerous other grounds. What happens if he wins his appeal? There are multiple avenues that he could win his appeal. The kind of top line is if he wins his appeal and gets a new trial, he gets a new trial. Also, he could win on certain points where the court says, yes, you're right. That shouldn't have happened. However, it's harmless error. If you get to harmless error, it's like, you're correct. That shouldn't have happened. But also NBD, and we're not giving you a new trial. So the most he can get from this is a new trial. Remember, Alex Murdaugh is still serving a buttload of time for his federal cases and his other state cases. So if he is granted a new trial, he is not going to get out on bail or bond. He is not going to be just bouncing out of prison, but it might change his housing status because then he would have to go back to trial. I don't know how he would pay for a new trial, but he would have to go back to trial. So if he wins his appeal, he can get a new trial. That is the most he can get. They are not going to exonerate him. They are not going to nullify the murder convictions. The thing he is looking for on this appeal is a new trial. That is what he wants. And on these facts, it is not the longest of long shots. We look at a lot of appeals and we're like, good luck with that. We've looked at some appeals where I'm like, actually, that has interesting points. And the appellate court is still like, nah, this one has some legs.
Now, I do want to go to the record fairly quickly and summarize it so that there's no misunderstandings. Rhonda McElveen, who's the Barnwell clerk of court, was asked by Becky Hill, the Colleton clerk of court, to assist her during the Murdaugh trial. She testified under oath that she was told by Ms. Hill that she, being Ms. Hill, might write a book because she needed a lakehouse. A guilty verdict would sell more books. That was said before December of 22. We didn't pick a jury until January of 23. The best way to sell books was a guilty verdict. A guilty verdict would be better for the sale of books. So she explained she had a financial incentive for a guilty verdict. She also made comments to her like, don't be fooled by the evidence presented by Mr. Murdaugh's lawyer. Watch him closely. Just before he testifies, look at his actions, look at his movements. Identical to the statements that I'm going to read you in just a moment by the jurors as they were questioned. Juror P, on the day Mr. Murdaugh was taking the stand, Becky Hill made a comment, watch his body language. Juror X, prior to Mr. Murdaugh's testimony, Juror X heard Becky Hill say words to the effect of, looks like the defendant's going to testify. This is an important day. This is an epic day. It's rare for a defendant to testify. Juror Z, watch his actions, watch him closely. In addition to that, Juror Z said in an affidavit and affirmed in court that Ms. Hill told her not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which she understood to mean Mr. Murdaugh would lie when he testified. And that Ms. Hill instructed the jury to watch him, Murdaugh, closely immediately before he testified, including look at his actions, look at his movements, which Juror Z understood to mean he was guilty. Alternate Juror 741. Before the defense put up their case, Ms. Hill told the jurors the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Hill told juror 741 Murdaugh was going to testify before he testified. That's what the juror said under oath. That's what the clerk of court of Barnwell County said under oath.
Can we consider the egg juror's affidavit?
I'd like you to.
Well, in the record, of course, you mentioned during the hearing, she's across the street. Judge Toll said, no, she's not going to testify. She let the alternate juror testify for impeachment of Ms. Hill. That's
Correct.
what her stated reason for was during the hearing. What was the rationale for her not allowing the egg juror to testify?
I don't know. Because as you point out, if juror 741 was to impeach Becky Hill's credibility, now of course, she was not a deliberating juror.
Well, neither was the alternate.
Correct.
Who did testify.
Correct.
So my question is this, and I'm sure Mr. Waters will cover this. If the egg juror's testimony was just as theoretically impeaching as juror 70 or the alternate juror's testimony, 741, why wasn't the egg juror allowed to testify?
And I'm not sure that she stated a coherent reason other than she wasn't going to. Remember now.
But she said her affidavit is in the record, so we know what she said, Ms. Hill said,
Right.
and we now know what Ms. Hill said she didn't say.
Yes.
So I take that to mean that it was considered. The egg juror's affidavit was considered by the court, and we can consider it.
I want to ask you a question about this idea that you expressed that this event or these moments when the clerk spoke to the jurors should be considered insignificant when viewed among the entire trial, whether it's a long or short trial. There's no eyewitness, there's no DNA, there's no one thing on the part of the state that you could rely on to show him guilty. So you had to piece together a whole bunch of different stuff. We'll talk about a lot of that stuff in the next phase. But
yes,
but you spent, most of that 6 weeks was you piecing together small pieces of evidence to put together an argument that he did it. Mm-hmm. On his side, now of course he doesn't have the burden and isn't even required to testify. But on his side, whether he's guilty or innocent boils down to one moment, one thing, and that's when Alex sat up on the stand and said, "I didn't do it." Mm-hmm. So what I'm wondering is, you're wanting us to consider the statements by the clerk to be insignificant, but those statements go to the only thing that the defendant really had. I mean, the defendant can argue that you didn't piece it all together, but really the defendant's argument boils down to the one thing that the clerk of court addressed. So we can look at all this context if you want to, but the jurors knew that if Alex was telling the truth, he's not guilty. If he's lying, he is guilty. And that's where the clerk of court's statements appear to focus.
Well, we see where this judge is coming from. It's a really interesting question because I hadn't thought about that. It's an interesting perspective when the justice is like, look, you have weeks and weeks and weeks to piece your case together. But when the clerk spoke to the jurors, it was going directly to the defendant's testimony.
As Justice Hull said, she finds it, she did not find that a few foolish and fleeting comments in the entirety of this trial would be enough to have infected this verdict and to make it unfair. I completely agree that somebody's entitled to all 12 jurors, but this is a credibility finding that 11 told the truth and 1 did not, and the 11 set the standard of what this court should consider, and those comments were not egregious.
I just want to, you can respond to the Parker versus Gladden part in a moment, but you also need to explain to me about the egg juror. She was removed from this jury on the day deliberations began. Is that correct?
Yes, sir.
So she was not an alternate. She was a sitting juror.
Correct.
Juror.
And so she was there and removed minutes before they began talking about the case, began deliberating, correct?
Correct.
It was so wild.
And she said in her affidavit
Back to the egg lady.
That her ex-husband called her as she was getting on the bus to ride to the courthouse that morning. That upset her because she had a restraining order prohibiting him from contacting her. So she called, or she spoke to Ms. Hill, correct?
Yes, sir.
And Ms. Hill told her, according to the egg juror, the Murdaughs probably got to him. You agree that's what she said in her affidavit?
That's what she said in her affidavit.
Okay.
What?
And then Ms. Hill asked her.
Keep in mind, we have not seen these affidavits. This is why they want to consider the egg lady affidavit. Because the egg lady affidavit was submitted and Justice Toll was, I don't even remember why Justice Toll was like, no, the egg lady juror is not testifying when they did the motion for new trial, but this is new.
And Ms. Hill told her, according to the egg juror, the Murdaughs probably got to him.
Holy shit.
You agree that's what she said in her affidavit?
That's what she said in her affidavit.
Okay. And then Ms. Hill asked her if she was leaning one way or the other. And the egg juror said, Mr. Waters' closing was good, but I still have questions. And she said, what kind of questions? And she told Ms. Hill she had questions about the guns. I suppose couldn't find them or there were two used. And then Ms. Hill asked her what makes you think he's innocent. And she said,
what?
The video at the kennels.
What?
And then she said, Ms. Hill said, everything the defendant has said has been lies, and you should forget about the guns. They will never be seen again.
What?
Are those fleeting comments or are those egregious?
What?
Your Honor, those would be hard pressed to defend. Yes, sir.
Okay.
That would be much different from what I'm arguing this record.
And then Ms. Hill told her that the four
There's more?
person should just go in and ask for a raise of hands, and this will be over and done with, and everybody needs to be on the same page. So I'm struggling.
Oh my God. We finished the first appellate argument, which focuses on the clerk of court, Becky Hill, and the fuckery that abounded therefrom. If Alex Murdaugh is going to get a new trial, it is going to be tied to the clerk of court. We haven't even watched the other part of the oral arguments yet, and we can see that the justices of the South Carolina Supreme Court feel very strongly about Becky Hill's actions. It is an affront to the entire system if someone within the judicial system is trying to put their hands on the scales of justice and push them one way. And the justices kept pointing to indications of where it seemed that the clerk was pushing on the scales of justice with the jurors, and then questioning about the propriety of whether or not you can inquire of the jurors if it had an impact on their decision making, because that starts to invade the deliberative process, and why the egg lady juror was not allowed to testify when one of the alternates was allowed to testify, so that Justice Toll, when hearing the motion for new trial and the evidentiary hearing connected to that, didn't take evidence and testimony from the egg lady, but the egg lady juror declaration is in the record, and all of the judges are like, can we consider the tea though, boo? And the defense is like, yes, you can. Yes, you can. Go get yourself a stroopwafel for the tea and consider all of it. And the prosecution's like, well, it's in the record, but I mean, it's all clout circus, and the egg lady juror was excused because she was talking about the case ahead of closing arguments with like everyone in the neighborhood. I'm exaggerating a bit on that. It was just a couple of people in the neighborhood. So we really can't consider that to be credible. But what we learn is everything that's in the egg lady juror affidavit that includes that Becca Boo was like, so which way are you leaning? And what are your concerns? And you have questions? Let me answer your questions. Don't worry about them guns. Everybody should just go in there and just raise their hand, and we'll just be done with this in just absolutely no time. Everyone needs to just get on the same page. And the foreperson should just take a show of hands vote, and we'll all just be done right quick. Wild. Absolutely so fucking wild that we learned so much more about the purported conversation that went down between Egg Lady Juror and Becky Hill before Egg Lady Juror was yeeted off the case at the precipice of deliberation.
This appeal presents 5 fundamental evidentiary errors that individually and cumulatively denied Alex Murdaugh a fair trial. First, the court admitted testimony from a cell phone forensic evidence who confessed that he had never actually done a physical experimentation like the one about which he testified and knew nothing more than anyone else in the courtroom. 2, the court admitted gunshot residue evidence from a blue raincoat, despite the fact that the only connecting witness definitively testified that what she saw was a blue tarp and could not be confused with a rain jacket. 3, the trial court admitted unfairly prejudicial evidence over 6 days regarding financial crimes spanning 6 years, the crimes that were committed by the appellants. 4, the prosecution violated Doyle v. Ohio by repeatedly impeaching Mr. Murdaugh regarding his post-Miranda silence after being arrested on the murder charges. And 5, the court admitted firearms identification testimony based upon unprecedented methodology that the expert himself could not state to any reasonable degree of certainty during the counsel hearing.
Now, what we did here, and I think this is the best practice, is we wrote a detailed pretrial motion and laid it entirely out, wrote out every bit of it, wrote out the entire theory, and put that out for the defense and said, Judge, defense, this is what we're planning on doing. And in opening, I was very careful. I just said, there's going to be things going on in his life. I didn't talk at all about that. And then we did the in-camera hearing, and we were very careful. And before I even broached those subjects, I raised that to the trial judge to ensure that the entirety of that was being considered.
Was there any 404B that was disallowed?
There was. So there was 404 of evidence of an affair that Marion Proctor and Maggie's concern.
What? Excuse me. We need to go back to the T. Okay, Creighton. Tell us.
Was being considered.
Was there any 404B that was disallowed?
There was. So there was 404 of evidence of an affair that Marion Proctor and Maggie's concern about affair that he excluded as too remote. And then there was a side of the road and narcotics evidence, but ultimately that eventually came into play because of opening the door.
Was there any 404B related to financial crimes that was disallowed?
Oh, boy. Well, the court ruled that Maggie's concerns that Murdaugh was having an affair was kept out by the court. That I remember the roadside stuff was kept out until he testified, and then it came in. And then he's now asking about any financial evidence that was kept out.
I think no, but I think that
That's what concerns me, and I want to just gently push back and give you an opportunity to respond. Yes, the judge is a gatekeeper. Unlike the federal counterpart of 404B, our case law has said that our version of 404B is a rule of exclusion, not inclusion.
Right.
And the gate here was just left open. And I couldn't find any example of financial crime evidence that was excluded. And the granular detail in the expansiveness of which everything under the sun was allowed is arguably problematic.
I think the jury tampering by the clerk is something they were engaged in. They asked very pointed questions of Creighton Waters. I feel that they're very interested in that. And again, you can't predict what they're going to do, but they were interested in the cases that we talked about. And I think when Phil got back up and they were asking questions about the clerk, and he pointed out she was a self-confessed perjurer, I saw one of the justices react to that. So, I mean, I think, look, do I regret anything we did today? No. Am I proud of the arguments we made? Yes. Did we cover everything we needed to cover? I think we did.
If Alex Murdaugh is given another trial, will you all be the ones who defend him?
You know, that's up to Alec, but right now we believe we will be.
And if he isn't, what's the next step?
Federal court.
We're at the end of the oral arguments for the Supreme Court of South Carolina. I really wish that defense counsel Barber had argued a lot more. I wish he would have just taken over whatever Jim Griffin was arguing and had just done that argument too. I personally find him much easier to follow. I understand Poot's style is always going to be very chummy, very Putin. And I think Creighton showed how much of a command of this case he has, not just fact for fact, but also getting into the case law in it. I've always enjoyed Creighton's style and his organization. I think Creighton had a very difficult early go because the facts are so hard to argue. The courthouse Becky stuff is just awful. It's just awful. There's no way around it. And it's really hard for Creighton to kind of spackle over the rough bits and say, yeah, it's not ideal, but it shouldn't be reversible. You should not grant a new trial because of courthouse Becky. When we get to the other arguments, you could see Creighton's demeanor and his argument change a little bit, much faster, much more, and then, and this fact, and this fact, and this fact, and this is how it all comes together, and this is why it's necessary. You can see with Creighton, it's easier to push into those later arguments in the analysis of the financial crimes, the analysis of how much 404 evidence came in this case, and then discussion of the other experts and an expert torn experiment. If the court, and it's going to take the court probably months to come back with a ruling on this, I wouldn't expect it in a couple of weeks. I would think we're a few months out. I don't know how fast the South Carolina Supreme Court generally rules. Most courts take a few months at a minimum. So it's not going to be anything swift. They are going to take those arguments under advisement. They're going to think about it. They're going to discuss with each other before they fashion a ruling. If they are inclined to grant Alex Murdaugh a new trial, there are a lot of grounds for them to do it. The courthouse Becky grounds, I think, are the easiest grounds for them to grant a new trial. The courthouse Becky stuff is really difficult to overcome, I think, for the state. And it's just going to depend on how the court wants to apply that standard, if they agree with the way Justice Toll applied that standard, or if they don't agree, or if they think that the standard should change because there is a split authority on the standard when it comes to state actors interfering with a jury. The second grounds on that are going to be the evidence. You heard the Chief Justice in this case talking to Creighton Waters about the vast and expansive financial crimes evidence, and was too much sympathetic evidence allowed in that went beyond just, yes, he stole from this client, yes, he stole from that client, fake forge and move on. And that was something that we discussed during trial. At what point is it too much piling on? Because if the court finds it's too much, that becomes easier grounds for appeal. The other things I think are a little bit more difficult, but point 1 and 2 is 100% the courthouse Becky issue and then the 404 financial evidence. It's really hard for me to get over the courthouse Becky stuff. And I'm interested to see what the court does because I can see them choosing to grant a new trial based on the courthouse Becky stuff. I think that's the easiest grounds for them to base a new trial. And I really think that they probably will. The courthouse Becky stuff is bad. And I don't think trying to find a way around how bad it is serves the purpose of the court. And I don't think it's what actually upholds justice. It's just really, really tough. So new trials are rare on appeal, but when you get to the end of this case and look at all the courthouse Becky stuff, do you have questions? And if the court's takeaway is this is unsettling, you cannot allow this to stand, you grant a new trial. And you take a look at the standard and say no. And you saw the Chief Justice talking about the courthouse Becky stuff saying, yes, maybe some of these things are innocuous, but even though some of these things look innocuous, when you take them all together, it's not just innocuous. And then you get one of the justices saying, right, the state has all these puzzle pieces that they're putting together, but the defense has the defendant's testimony. That is the main point of their case, is the defendant's testimony. And when you get to the defendant's testimony and you've got the clerk of court saying, watch his body language, it's an epic day, pay really close attention. And one of the jurors saying, and then Egg Lady juror saying everything, but one of the jurors saying that her takeaway from what Courthouse Becky said was Courthouse Becky's, the way that she was talking about don't let him fool you was the insinuation that Murdaugh was just going to get on the stand and lie. And once you have somebody comfortable enough to start seeding those thoughts to jurors before the defendant even testifies, how can you know that their verdict wasn't impacted by that? And so I will be very interested to see. I think it is a possibility. And in most appeals, I'm like, yeah, good luck with that. I think it's a possibility. I think the court acknowledged multiple times, and the defense attorneys and all the attorneys acknowledged multiple times, nobody wants this to go to another trial, but that might be what justice requires. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.